judicial or policy litmus test?
Judicial
or policy litmus test?
I didn't hear you well.
What is your stand on gun ownership?
Gun ownership. Gun. In fact, I think our laws are such that if you want to own a gun, first and foremost, you need to register it. So if your gun is unregistered, then you have already violated the law. And I'm sure that this is to prevent people from, using the gun not intended for the purpose for which the gun was acquired. So my position is that if you want to own a gun, first you must be an adult, and then you must also register it as the law requires. Thank you.
Thank you. The second question is, what is your view on the doctrine of separation of powers?
Separation of powers, it's, somebody will say it's a political doctrine where the three arms of government are given their specific rules to play. And that's overlap. It's overlap in the sense that you can't say that because you are a judiciary, you will not have anything to do with the executive, and that the executive will also not have anything to do with the legislature. In fact, the core idea of separation of powers is to ensure that the three arms of government, there will be checks and balances. So no one arm will be controlling the others. So for example, it's the duty of you as honorable members of this House to ensure that when the executive is going astray from what it is required or they are required to do, you have the power to say that, no, this one, you are going ultra vires your powers. The same with Parliament. If Parliament passes laws which are ultra vires their powers, the judiciary should be able to tell the lawmakers that, look, here it didn't go well. You should have done this or you should have done that. So it's about ensuring that there are checks of balances so that there will be cohesion. After all, that is what good governance is all about. Thank you.
Please do. Thank you. My Lord, in recent past, the last few years, you have some interference and overlapping where Parliament is making decision, is not yet concluded, and yet the judiciary jump on it to make decisions to stop it. Is that not usurping of or interference in the separation of powers?
Thank you, Chairman. The law, as I understand it, is that if what the Parliament sought to do has to do with interpretation of the Constitution, then the judiciary is seized with that jurisdiction to go into the matter. It's not as if the judiciary is becoming a schoolmaster. Of course, in any event, even say it, of your rules. If the rules are fashioned in consonance with the law, and for that matter, the Constitution, I do not think the Supreme Court will jump onto your head and say that, don't do this, don't do that. So I would say that that case in question that you are talking about, if it bordered on constitutionality and interpretation of some provisions of the Supreme Court has a right to intervene. Thank you.
I wish you all. Thank you so much.
I'll then proceed to give the floor to Honorable Jerry Shaib.
Thank you very much, Honorable Chair. Honorable Chair, let me take this opportunity to welcome the Honorable Nominee and Nana Doctor and all the. I have a parcel of land in that area, so by extension, I'm a sub-chief.
Is that part of assets that you have declared?
Mr. Chair, I was given the land last night. Thank you very much. Nana Justice, congratulations and you are welcome.
Thank you. Thank you.
Honorable Nominee, you've been a registrar of the court, and I believe for a period before getting to the High Court and then the Court of Appeal. And therefore, you are versed with a lot of knowledge on judicial matters. Respectfully, would you recommend any judicial reforms to this committee?
Certainly. Thank you. I've already made mention of some reforms that we can put in place to ensure that cases that come before us are tried closely, and are made up. I think the rules of that we also work with needs looking at again. For example, the High Court rules, CI 47. Indeed, we had the previous one, which was promulgated in the 50s. It was only in 2004 that we changed it, and that has become our tool that we work with. Now, there are also inherent difficulties or problems with some rules of our engagement. For example, interlocutory appeals. I'm talking about interlocutory appeals, both in civil and in criminal. Interlocutory appeals, when a decision is made by a trial judge, while the case is still pending, most often the party that is dissatisfied will want to go and appeal. In that case, and if he applies for stay of proceedings, it's certify the hearing of the case. So I want to suggest that, yes, they have the right to appeal, but there must time limits within which the appeal must be heard so that it doesn't affect the hearing of the case adversely. Now, coming to the criminal aspect of it, now this has become fashionable that if you are doing a case as a judge, when you cough, a party will want to go up. When you sneeze, and sometimes they go even as far as to the Supreme Court. Meanwhile, then the case will still be pending. So I strongly advocate that the right of parties filing interlocutory appeals in criminal cases where the prosecution has not even ended its case must be stopped. And we can only do that through the amendment of the law, that is Act, talking specifically about Act 30. Now, another area which also needs reforms is our jury system. We inherited this system from our colonial masters, Britain, where they started this. Like India, Singapore, and South Africa, they have abolished the system. Why? Because it's not functional. Now, our experience in our jurisdiction has shown that that system has outlived its usefulness. So I would advocate that instead of the jury system, there must be assessors. Now, if you permit me, I will give one example. When I was in the High Court, I did assizes. That was before my transfer to Secondary in 2015. I did a case where I had summed up the evidence to the jury. And as much as possible, I did it that everybody in the courtroom, or maybe those in the courtroom who understood what we were saying, anticipated that the jurors were going to, bring a verdict of guilty. They came out and said that the accused persons were not guilty. And you see, the law is also that they are the judges of fact. So their verdict is even binding on you, the judge. You may disagree, but you cannot open your mouth. You have to work with it. And there was a doctor who has been subpoenaed. I've come from Ankafor Psychiatric Hospital to give evidence in the case. The doctor was in the court when I was delivering my seminar. The man was so disappointed that he said that if that is what the jurors here are doing, that I will never come back again. He didn't come. So the case will have to be, I left it because I was then on transfer to Secondary. So we can give examples, but because of constraints of time, I will not do that. But I'm saying that in its place, we should establish what we call assessors. In assessors, the judges who will try the case will be three, and there will be lawyers. I mean, there will be lawyers who have become judges. They will sit on the case. And we have it on our statute books when judges try treason and high treason offenses. It's assessors. We don't do it jury. Our jury system here is porous. Some of them have become professional jurors. So that is one area which I will advocate. Thank you.
Thank you very much. My Lord, I asked this question yesterday. I think it was Sir Dennis, my Lord Sir Dennis, that responded. But just opposing that with his response and yours, I'm looking at the issue of, for instance, the criminal interlocutory appeal that maybe a suspect or a witness believes that whatever ruling you made or whatever consideration you made would affect him or her. And if it is not corrected at the point that it has to be corrected, you would end up giving a judgment that would convict him and others. You don't think that the issue of time is key? That's what you said. But are you in the position to propose the time frame within which such appeals should be considered? Which I think is very, very crucial. Because if, for instance, I'm able to know that I can get an appeal for an interlocutory matter so that the court can proceed to deal with a substantive matter, would you consider giving us an idea of what time that appeal should be considered?
In my earlier submissions, I did make a point that if a party is aggrieved with a decision by a court, because the case has not traveled to its end and it is still ongoing, then that will be an interlocutory decision that by the court. Now, it's tried that when a case has not come to an end, or when in criminal matters, when the prosecution has not closed its case, the judge has no power to convict. Therefore, if you want to appeal against an interlocutory decision, you will not be, as it were, at that stage, the court cannot convict you and sentence you. So earlier when I did propose that right for parties, it could be the prosecution or it could be the defense, to file interlocutory appeals while the case is pending, must be reserved to the end of at the end of the course of the prosecution's case. That one is allowable. I think that so that the hearing of the substantive matter does suffer. Now, if it comes to the time that we should allocate for filing of the appeal and hearing it, I will propose that when the appeal is filed, interlocutory appeal is filed, the registrar should be able to compile the appeal within 14 days. Because invariably, it's not every document that has been tendered in the proceedings that will have to be embodied in the record of appeal. It's only if it's an application, yes, it will take the processes that were filed in connection with that application, and then the decision of the court itself, that will be the relevant records that must be sent to the Court of Appeal. And when it is sent to the Court of Appeal, then the rules of court must also amend the rules to say that if it's an interlocutory appeal and it's of urgency, it's urgent, then that appeal must be heard within at most, is it at least or at most 30 days, so that it will not badly affect the hearing of the substantive case at the trial court. So that is my proposal.
Very well, thank you very much, my lord. My lord, were you once a magistrate, and would you pray that career magistracy be abolished?
Not at all. I would rather advocate that the system must be, must be strengthened, for want of a better word. Because you see, this career magistrate came about as a result of when the Courts Act was amended. First we were sitting as tribunals with, panel members. I think in 2001 or so, when President Kufuor came into office, the Parliament sought to reverse the system back to its former. So now, then we had magistrate. Because of the vacuum that was created, most of the there were so many vacancies. So that was why at that time it became necessary for the then Chief Justice to fashion out this career magistrate system. And it is not, Ghana is not the only place that we have, applied this system. When you go to Nigeria and Zimbabwe, they have that system. And there's a career part where you can start as a career magistrate, and you, by dint of hard work, integrity, and your competence, you can rise to become chief magistrate, which is an honorous grace of a high court judge. Now, here, there's some difficulty with our system. Currently, because the service felt that we must encourage lawyers to come to occupy those positions. And as I said earlier on, the lawyers, when they want to join the service, want to start from the superior courts. So, as at now, there are about 20 plus more career magistrates in the system, and those ones are in the hinterlands. And they do the same work as that of, professional lawyers who have become magistrates. So instead of scrapping it, it should be strengthened. They must be given the opportunity to also go to the law school, educate themselves, because when they come back, they also come and join the service. There is a second judge in Kumasi. He started as a career magistrate. He had the opportunity to go to school, and now he's a second judge. So instead of scrapping it, because if you scrap it, and there are vacancies in the hinterlands, as Madam was saying, who will go there to, do the, as this career magistrates who have been going push to the hinterlands to handle the courts there. And it's important that we should, encourage them to also come up with their competence.